Hi, this is Professor McLaughlin with a brief video on concepts of interviewing and investigation. This is not heavily covered in your textbook. I will upload some additional reading for your enjoyment, but if you are feeling overwhelmed by all the reading we're doing this summer, I will say you can complete the assignments without doing this reading, but it really is a nice little chapter and resource on ethical and professional responsibilities and good strategies for interviewing and investigating. So in wills, trusts, and estates, you're doing a lot of interviewing, and we'll use the word investigate with a small I. You may be collecting records, looking for information, helping the personal representative, maybe even helping the testator as they draft the will, as they're trying to, but that's less um, likely. Mostly you'll be helping the personal, I believe you'll be helping the personal representative find documents, and look for things. So when you are interviewing or doing intake for a client, either in wills and trusts or any other practice area, these are all transferable skills to other practice areas where you're interviewing clients. You want to have your questions known to you beforehand, and you want to have developed some skills for conducting the interview and how to record answers in a way that suits you and also suits the practice that you're in, wills, trusts, and estates or otherwise. Make sure you have looked at the file and you're not asking questions that you already have the answers to. You may have to do maybe some preliminary legal research, prepare your questions, understand how the interview or intake is going to happen. Is it going to be over Zoom, over phone, in person? And be aware of the room that you're in and whether it's seating arrangements or making sure the client has water. So in terms of interviewing, and these are uh, broadly uh, well-used approaches for questioning in general, I would say, in the legal profession. Approaching an interview with the story approach would be you just want the client to tell you a story. Tell me what happened. You're not interrupting and asking questions. You're taking notes and letting it flow. Let that flow happen and then ask questions afterwards. A related approach, the silent approach, it sounds horrible, but this too is with the story approach, you are coaching along the storytelling. So you might have to interject, well, what happened next? What happened after that? Is that all that happened? With the silent approach, you're not being rudely silent or scary silent. Instead, you are consciously and intentionally being quiet because some clients may need that approach, that space to speak. It may take them a while to get going. They may be terrible storytellers, or they may tell the story while they get comfortable with you and begin to trust you. And then you may need the silent approach just because you've created the relationship, and maybe being quiet while they talk is effective. And then the question approach. Sometimes if the storytelling is going on and on, or it has digressed from what I think are is necessary information. So if the client has started telling a story and it is now digressed into things that happened when they were a child, and that's not relevant to um, the matter that that I need to help them with, then I interrupt and ask questions. So I use questions as a way to also set boundaries and move things along. So the question approach can be open questions where you're just asking it's really a prompt. How did it begin? It could be closed questions such as tell me that date, what what was the weather like? Something very specific. Leading questions, we've seen this on television, where the answer is part of the question. You want the client, you want to know for intake and interviewing, I don't think you really need leading questions, but you should know what they are. And then hypothetical and prompting questions. Sometimes hypotheticals are useful if the client is having trouble understanding you and you need to say, well, imagine this happened. And if that happened, what would the response be? So we can maybe all think of a fact scenario where asking hypothetical and prompting questions are useful. Intake and interviews, make sure you're on time. Make sure everybody's always aware if you are not an attorney, um, that they understand who you are. Take notes, but also make sure you have looked at the video on emotional intelligence. You need to look up, you need to nod, you need to indicate that you are attentive and there. And what I do is frequently with clients say, I'm going to take notes. So if you see me writing things down, don't be concerned. That's just so I have a record of what we're talking about today. Maybe the client needs tissues or some water, or they too would like to take notes. Maybe you've asked them questions, or there are documents that they need to go home and look for, and they want to take notes. Look for nonverbal clues, take breaks if that's necessary, reschedule if that's necessary, if you have an ill client, and put yourself in a very neutral mindset. Even if even if the client says things maybe are not true or seem exaggerated, or they're trying to talk about the law, you can be open. You can redirect the conversation back to the information you need to get, but be flexible. Don't judge the client. I like these little tips and tricks, using a different colored pen for questions. I use different colored pens frequently when I'm reading cases or reading um, law review articles, to distinguish between certain things you choose. So I do like those tools. You may need to follow up after the interview, call the interviewee if there's anything else. But typically with intake, with wills, trusts, and estates, and there is a sample intake form for you in your Canvas, you're not, maybe you're following up. Yeah. I can see where you would follow up with, hey, did you find that birth certificate, or did you find the document we were looking for? So that's a possibility. And if you do take a look at the reading that I post, there is some investigation. It's really minimal. And I don't know if I would call it investigating, but legitimately sometimes it is. You're locating information, you're looking for documents, you may be looking for people, you may be looking on social media. Family law, wills, trusts, and estates frequently is about finding information, finding heirs. And for that, hopefully you'll be trained on this, or following if you're a new paralegal, following a more experienced paralegal around. We're not really doing criminal. You're not working with a private investigator in wills, trusts, and estates usually. But here are some of the things you can focus on. And, this has changed over time. There's so much more on the internet. But still finding records through the county or state or the court is always a good place to start. Thank you. I'll see you more online.